I knew the moment I installed that generator shed in my backyard that I'd have to deal with the HOA eventually. But I never imagined it would turn into a full-blown war with inspections, lawyers, and criminal charges hanging in the balance. My name is Warren Hutchins, and I live in the Pleasant Meadows subdivision in Raleigh, North Carolina. I'm a software engineer who works from home, which means reliable power is absolutely critical for my livelihood. After the third major power outage in 18 months knocked out my internet for 6 hours and cost me a lost client, I decided enough was enough. I researched generators, talked to contractors, studied the building codes, and built myself a proper generator shed that met every single specification required by the city of Raleigh. The shed itself was a thing of beauty in my mind. 10 feet by 8 feet, positioned exactly 12 feet from my property line, painted to match my house's trim, with proper ventilation, concrete pad foundation, and a Generac 22 kW standby generator that could power my entire home during an outage. I'd pulled all the necessary permits from the city, had the electrical work done by a licensed electrician, and passed every inspection with flying colors. The whole project cost me nearly $15,000, but it was worth it for the peace of mind. I finished the installation on a Tuesday in March. By Thursday afternoon, I had a letter from the HOA in my mailbox. The letter was printed on cream-colored cardstock with the Pleasant Meadows Community Association letterhead emblazoned across the top. It informed me in the coldest possible language that my generator shed was in violation of the community covenants and must be removed within 30 days, or I would face fines of $100 per day until compliance was achieved. I read the letter 3 times, trying to figure out what violation they were talking about. The letter cited Section 7.3 of the covenants, which I'd read before starting my project. That section dealt with outbuildings and stated that any structure over 100 square feet required prior approval from the Architectural Review Committee. My shed was exactly 80 square feet. I'd specifically designed it that way to avoid needing their approval. The next morning, I called the HOA management company. A bored-sounding receptionist transferred me to someone named Patricia who handled compliance issues. "Yes, Mr. Hutchins, we're aware of your situation," Patricia said in a tone that suggested this was already a tedious conversation for her. "The ARC has determined your structure violates community standards." "Which standards exactly?" I asked, keeping my voice level. "My shed is under the size threshold that requires approval. I checked before I built it." "The committee has determined that the visual impact of the structure is inconsistent with neighborhood aesthetics," Patricia recited, clearly reading from something. "Additionally, the noise from the generator creates a nuisance. The generator isn't even running most of the time. It only kicks on during power outages or for its weekly 5-minute test cycle. Be that as it may, the structure must be removed. You have 27 days remaining." I hung up feeling frustrated but not worried. I had documentation proving I'd followed all the rules. This would sort itself out. It did not sort itself out. 2 weeks later, I received another letter, this time informing me that my daily fines would begin in 13 days. The letter was signed by Brenda Morrison, president of the Pleasant Meadows Community Association. I decided it was time to attend an HOA board meeting. The meetings were held on the first Tuesday of each month in the community clubhouse, a bland building near the subdivision entrance that also housed a small gym and a pool that was only open 3 months of the year. I arrived at 7 in the evening to find about a dozen other homeowners scattered across the folding chairs facing a long table where 5 board members sat. Brenda Morrison was exactly what I'd expected. Mid-50s, highlighted blonde hair cut in that specific style that seemed to be standard issue for HOA presidents everywhere, designer reading glasses on a chain around her neck, and an expression that suggested she smelled something unpleasant. She sat in the center of the table, flanked by 4 other board members whose names I didn't yet know. The meeting started with approval of the previous month's minutes, followed by a treasurer's report that revealed the HOA had nearly $200,000 in reserves. Then came homeowner concerns. I raised my hand. Brenda's eyes fixed on me with immediate recognition. "Warren Hutchins, 842 Oakmont Drive," I said, standing up. "I'm here about the violation notice regarding my generator shed. I'd like to understand specifically what covenant I've violated, because according to my reading of Section 7.3, my structure is compliant." Brenda didn't even consult any notes. "Mr. Hutchins, your shed is an eyesore and the generator creates excessive noise. The ARC has denied your structure." "I didn't submit it to the ARC because it doesn't meet the size threshold requiring approval," I replied. "It's 80 square feet. The covenant says structures under 100 square feet don't need prior approval." "The ARC has the authority to review any structure if it impacts neighborhood aesthetics," Brenda said firmly. "Your shed is visible from the street and doesn't match the approved style guidelines." "What approved style guidelines? There's nothing in the covenants about generator sheds." "The ARC maintains discretionary authority over architectural decisions." "Can I see the specific written guidelines my shed violates?" Brenda's expression hardened. "Young man, this association has standards. We don't allow whatever ramshackle constructions homeowners feel like throwing up in their yards. Your shed looks like something from a junkyard." Several homeowners turned to look at me with interest now. I felt my face getting hot, but kept my composure. "My shed is professionally built, painted to match my house, and meets all city building codes and inspections. I have the permits and inspection certificates if you'd like to see them." "City codes are minimum standards," Brenda said dismissively. "Our community maintains higher standards." "The shed must be removed. If you wish to house a generator, it must be inside your garage or in an approved enclosure that meets ARC specifications." "My garage doesn't have space for a generator installation, and you haven't provided any specifications for an approved enclosure." "Then perhaps you should reconsider whether this community is the right fit for your needs," Brenda said coldly. I sat down, understanding that this conversation was going nowhere. After the meeting ended, a few neighbors approached me. One of them, an older man named Richard who lived 2 streets over, told me he'd been through similar battles with Brenda over the years. "She thinks this HOA is her personal kingdom," Richard said quietly. 3 years ago, she tried to fine me for painting my front door navy blue instead of the approved forest green. I had to threaten legal action before she backed down. "Document everything, keep every letter, and don't let her bully you." I thanked him and left feeling more determined. If Brenda wanted a paper trail, I'd give her one. Over the next week, I compiled my documentation. I had the building permit from the city, the electrical permit, the final inspection approvals, photos showing my shed from multiple angles, measurements proving it was under the size threshold, and copies of the relevant covenant sections. I also researched North Carolina HOA law and discovered that HOAs couldn't enforce rules that contradicted local building codes or create restrictions that weren't explicitly written in the recorded covenants. I sent a certified letter to the HOA management company with copies of everything, along with a formal request for the specific written guidelines my shed allegedly violated. I cited the relevant state statutes and requested an appeal hearing before the full board. The response came from a lawyer. The law firm of Davidson and Associates represented the Pleasant Meadows Community Association. Their letter, which arrived 10 days before my fines were supposedly set to begin, informed me that my appeal was denied. My shed remained in violation, and if I didn't remove it by the deadline, the HOA would pursue legal action to compel compliance and collect fines. That's when I decided to hire my own lawyer. My attorney's name was Jennifer Cordova, and she specialized in property law and HOA disputes. She was probably 40 years old, sharp-eyed, and had a reputation for not backing down from neighborhood association fights. Her office was in downtown Raleigh, and when I met with her to explain my situation, she listened carefully and took extensive notes. "This is actually pretty straightforward," Jennifer said after reviewing my documentation. "Your shed complies with the recorded covenants. The HOA can't enforce unwritten standards or arbitrary aesthetic judgments. North Carolina law is clear on this." "So what do we do?" I asked. "First, I'll send them a letter explaining that their violation notice is improper and that you're in compliance with the covenants. I'll point out that pursuing fines or legal action would be a violation of North Carolina General Statute 47F, which governs HOA conduct. If they continue, we'll file for a declaratory judgment and potentially countersue for harassment and legal fees." "How much is this going to cost me?" "My retainer is $3,000. If this goes to court, it could be more, but honestly, most HOAs back down once they realize the homeowner has proper legal representation. They don't want to risk losing and having to pay your legal fees on top of their own." I wrote the check, feeling simultaneously relieved and angry that I had to spend money defending something I'd built legally in the first place. Jennifer's letter went out the next day. The response from Davidson and Associates came within a week, and it wasn't what we expected. Instead of backing down, they doubled down. The letter claimed that my interpretation of Section 7.3 was incorrect, that the ARC's authority was absolute regarding aesthetic matters, and that my shed violated multiple unspecified community standards that didn't need to be explicitly written in the covenants because they were implied by the association's general authority. "This is nonsense," Jennifer said when she called to tell me about the response. "They're making up legal theories that don't exist. I think they are hoping you'll just give up." "I'm not giving up," I said. "What's next?" "Next, we file a complaint for declaratory judgment. We'll ask the court to rule that your shed complies with the covenants and that the HOA's violation notice is improper. I'll also request that the court enjoin them from assessing fines." The legal papers were filed within 2 days. The HOA had 30 days to respond. During this time, strange things started happening. I came home from a grocery run one Saturday to find orange spray paint on my driveway marking utility locations, even though I hadn't called for any utility locates. When I called the utility company, they had no record of a locate request for my address. 3 days later, I received a violation notice about my lawn being over the maximum allowed height. I'd mowed 4 days earlier. I measured my grass. It was 2.5 inches tall. The covenant specified grass couldn't exceed 4 inches. Then came a notice about my trash cans being visible from the street. They'd been in the same location beside my garage since I moved in 3 years ago, and I'd never received a complaint before. I forwarded every notice to Jennifer, who documented everything. "They're retaliating," she said. "This is actually helpful for our case. It shows a pattern of harassment." The breaking point came on a Tuesday morning in early May. I was working from home, on a video call with a client in California when I heard heavy machinery in my backyard. I excused myself from the call and looked out my window to see a pickup truck parked in my driveway and two men attempting to attach a chain to my generator shed. I ran outside. "What are you doing?" One of the men, wearing a dirty t-shirt and work boots, looked at me with confusion. "HOA hired us to remove this shed. You Hutchins. This is my property. You can't just remove my shed. Lady from the HOA said you were notified. We got a work order." "I don't care what you have. This is my property and you're not removing anything. Leave now or I'm calling the police." The man shrugged and pulled out his phone. He walked away, speaking to someone I couldn't hear. After a minute, he came back. "Lady says she's got the authority to remove non-compliant structures. The lady is wrong. Leave, now." I pulled out my own phone and called Jennifer. She answered immediately and I explained what was happening. "Put me on speaker," she said. I switched to speakerphone. Jennifer's voice was loud and clear. "Gentlemen, this is Jennifer Cordova, attorney for Mr. Hutchins. The structure you're attempting to remove is the subject of ongoing litigation. If you remove or damage it, you'll be liable for destruction of property, and Mr. Hutchins will file a police report for trespassing and vandalism. I strongly suggest you leave immediately." The two men looked at each other. The one who'd been doing the talking shook his head. "Not worth it." "We're leaving." He called whoever had hired them back. "Yeah, we're not doing this. His lawyer's involved. Find someone else." He hung up and looked at me. "No hard feelings, man. We just take the jobs we're given." They unhooked the chain, got in their truck, and left. I was shaking with adrenaline. Jennifer stayed on the phone. "Warren, I want you to call the Raleigh Police non-emergency number and file a report. What just happened was attempted destruction of property. I'm also going to file an emergency motion for a temporary restraining order against the HOA to prevent any further action regarding your shed until the court hearing." I filed the police report that afternoon. The officer who took my statement was sympathetic, but explained that since nothing was actually damaged, it would be difficult to pursue criminal charges. However, the report would be on file, which would help if there were further incidents. Jennifer's emergency motion was filed that evening. The hearing was scheduled for 3 days later. The temporary restraining order hearing took place in Wake County Superior Court. It was my first time in a courtroom, and the experience was intimidating. The judge was a gray-haired woman named Judge Patricia Connolly, who had a reputation for not tolerating nonsense. Jennifer presented our case efficiently. She showed the court my building permits, inspection certificates, photos of the shed, and copies of the covenant language proving my shed was compliant. She also detailed the escalating harassment, including the attempt to remove the shed without a court order. The HOA's attorney, a man named Martin Davidson from the firm that had been sending the letters, argued that the HOA had broad discretionary authority and that my shed was a safety hazard and aesthetic violation. Judge Connolly listened to both sides, reviewed the documents, and then asked Davidson a simple question. "Counselor, can you show me where in the recorded covenants your client has the authority to prohibit a structure that's under the size threshold requiring approval?" Davidson fumbled through his papers. "Your Honor, Section 7.3 grants the ARC authority over architectural decisions. For structures over 100 square feet," the judge said. "Mr. Hutchins's shed is 80 square feet. Where is your authority?" "The ARC maintains general authority over neighborhood aesthetics." "Show me the written standard the shed violates." Davidson couldn't, because there wasn't one. Judge Connolly issued the temporary restraining order on the spot. The HOA was prohibited from assessing fines. attempting to remove the shed, or taking any action regarding the structure until the full hearing on the declaratory judgment, which was scheduled for 8 weeks later. I left the courthouse feeling victorious, but Jennifer warned me not to celebrate yet. "We won the battle, not the war," she said. "The full hearing is what matters. That's where we'll get a permanent ruling." Over the next 8 weeks, the harassment continued in petty ways. I received violation notices for weeds in my flower bed, for parking my car on the street overnight during a dinner party, and for having a garden hose visible in my front yard. Each notice went straight to Jennifer, who compiled them into a growing file of retaliatory conduct. Meanwhile, I decided to go on the offensive. I requested copies of the HOA's financial records, which North Carolina law entitled me to see as a homeowner. When the records arrived, I spent several evenings going through them carefully. What I found was disturbing. The HOA was paying Davidson and Associates enormous legal fees, far more than seemed necessary for basic HOA legal work. In the past 3 years, over $80,000 had been paid to the law firm. I dug deeper and discovered that most of those legal fees were related to disputes with homeowners over petty violations. I also found something else interesting. Brenda Morrison's husband owned a property management company. Not the one that currently managed Pleasant Meadows, but one that had submitted a bid to take over management. The current contract was up for renewal in 4 months. I shared all of this with Jennifer. "I think there might be a conflict of interest here," I said. "What if Brenda is using these disputes to rack up legal fees and create dissatisfaction with the current management company so she can push the board to hire her husband's company?" "That's speculative," Jennifer said, "but it's worth investigating." "Can you attend the next board meeting and ask about it publicly?" The board meeting was 2 weeks before our court hearing. I arrived early and brought printed copies of the financial records showing the legal fees. About 20 other homeowners were present, more than I'd seen at the previous meeting. When the homeowner comment period arrived, I stood up. "I'd like to discuss the association's legal expenses," I said. "According to the financial records, we've paid over $80,000 to Davidson and Associates in the past 3 years. That's nearly 40% of our annual budget going to legal fees. Can the board explain why our legal costs are so high?" Brenda's face flushed red. "Legal expenses are necessary to maintain community standards. $80,000 to argue about grass height and shed aesthetics?" I asked. For comparison, I called 3 other HOAs of similar size in Raleigh. Their average annual legal expenses are around $5,000. "Why are ours 16 times higher?" Several homeowners murmured in surprise. One woman in the back called out, "I'd like to know that too." Brenda shuffled papers. "Every community has different needs. Our standards are higher, which requires more legal oversight. I've also noticed that the management company contract is up for renewal soon," I continued. "Has the board considered why these high legal fees might be creating dissatisfaction with the current management?" "What are you implying, Mr. Hutchins?" Brenda asked sharply. "I'm implying nothing. I'm asking direct questions about how our association dues are being spent." Another board member, a younger man named Tom, spoke up. "Warren has a point, Brenda. I've been concerned about the legal expenses too. Maybe we should ask Davidson to provide a detailed breakdown." "The legal work is necessary and appropriate," Brenda snapped. "If homeowners simply followed the rules, we wouldn't need extensive legal representation. But we're creating the violations through overly aggressive enforcement," Richard, my neighbor who'd warned me about Brenda, said from his seat. "I've lived here 8 years, and we never had these problems until 2 years ago when you became president, Brenda." The meeting devolved into arguments. Several homeowners expressed frustration with petty violation notices they'd received. Others defended the board's right to enforce standards. Brenda tried to regain control but couldn't stop the tide of complaints. The meeting ended with no resolution, but I could see cracks forming in Brenda's authority. Several homeowners approached me afterward to share their own stories of harassment and excessive violation notices. The court hearing arrived on a humid Thursday in July. Jennifer and I arrived at the courthouse at 8:30 for our 9 o'clock hearing. Martin Davidson was there with Brenda Morrison and another board member. Judge Connolly called our case promptly at 9. Jennifer presented our argument methodically. The shed complied with the size requirements in Section 7.3 of the covenants. It met all city building codes and had passed all inspections. The HOA had provided no written standards that the shed violated and had attempted to enforce arbitrary aesthetic preferences that weren't in the recorded covenants. Furthermore, the HOA's conduct showed a pattern of retaliatory harassment. Davidson argued that the ARC had broad authority to make aesthetic judgments, and that allowing the shed would set a precedent that would lead to declining property values and neighborhood deterioration. Judge Connolly asked the same question she'd asked at the temporary hearing. Where in the written covenants does your client have the authority to prohibit this shed? Davidson again tried to argue about general ARC authority and implied standards. Counselor, Judge Connolly said with barely concealed impatience, North Carolina law is clear. HOAs can enforce the covenants as written. They cannot enforce unwritten rules or arbitrary aesthetic preferences that aren't explicitly stated in the recorded covenants. Your client has failed to identify any written standard Mr. Hutchins violated. Unless you can show me specific covenant language that his shed violates, I'm prepared to rule. Davidson requested a brief recess. Judge Connolly gave him 10 minutes. He spent that time in urgent whispered conversation with Brenda in the hallway. When court resumed, Davidson stood and said, Your Honor, the association wishes to reconsider its position. Given the court's interpretation, perhaps we were overly aggressive in our enforcement. Perhaps, Jennifer interjected. Your Honor, the HOA attempted to physically remove my client's property without a court order, has subjected him to months of retaliatory violations, and has forced him to spend thousands in legal fees defending a structure that clearly complies with the covenants. We're requesting a declaratory judgment that the shed is compliant, an injunction against further HOA action regarding the shed, and reimbursement of Mr. Hutchins's legal fees. Judge Connolly nodded. Mr. Davidson, does your client oppose the declaratory judgment that the shed complies with the covenants? Davidson looked at Brenda, who shook her head reluctantly. No, Your Honor, we'll accept that ruling. And the injunction against further action, no opposition, legal fees. Davidson hesitated. Your Honor, the association was acting in good faith to enforce what it believed were appropriate standards. Jennifer stood. Your Honor, the association hired contractors to remove my client's property without legal authority. That's not good faith. That's harassment and potentially criminal. The association should absolutely be responsible for the legal fees they forced Mr. Hutchins to incur. Judge Connolly reviewed her notes. I agree with Miss Cordova. The HOA's conduct went well beyond aggressive enforcement, ordering in my favor. Mr. Hutchins's shed is declared compliant with the Pleasant Meadows covenants. The HOA is enjoined from any further action regarding the shed, or from assessing any fines related to it. The HOA shall reimburse Mr. Hutchins for his reasonable legal fees and costs within 30 days. Miss Cordova, Please submit your fee statement to opposing counsel. The gavel came down. We'd won. In the hallway afterward, Jennifer shook my hand. Complete victory. They'll have to pay your legal fees, which with my time and the court costs will probably run around $8,000. Plus they wasted their own legal fees. This was expensive for them. I felt relief wash over me, but also anger at having been put through this in the first place. What stops Brenda from doing this to someone else? Nothing, unfortunately. That's a battle the homeowners have to fight through the board election process. As we stood there talking, Martin Davidson approached. Mr. Hutchins, Miss Cordova, my client wishes to avoid further conflict. The association will comply with the court's order fully. See that you do, Jennifer said coolly. Davidson hesitated, then added in a lower voice, for what it's worth, I advised against the escalation, but clients don't always take good advice. After he walked away, Jennifer turned to me. He just told you that Brenda was driving this, not him. That's interesting. File that away. I went home feeling vindicated but exhausted. The whole ordeal had taken 4 months of my life and caused incredible stress. I'd won, but it shouldn't have required a lawsuit to build a code-compliant shed in my own backyard. 2 weeks later, I received a check from the Pleasant Meadows Community Association for $8,300, representing my legal fees. I deposited it and hoped that would be the end of things. It wasn't. A month after the court ruling, I received a notice in the mail about a special assessment. Every homeowner in Pleasant Meadows was being charged $500 to cover unexpected legal expenses. The notice explained that the association's legal costs had exceeded the budgeted amount, and the special assessment was necessary to maintain adequate reserves. I was furious. The HOA had lost an expensive legal battle due to Brenda's ego, and now every homeowner was being forced to pay for it. I called several neighbors who were equally angry. Richard suggested we organize. Within a week, we'd formed an informal group of about 30 homeowners who were fed up with Brenda's leadership and the excessive legal expenses. We decided to attend the next board meeting in force and demand accountability. The meeting was standing room only. Brenda looked surprised and uncomfortable at the turnout. When the homeowner comment period arrived, Richard stood up first. "This special assessment is unacceptable," he said. The board wasted association funds on an unnecessary legal battle that the HOA lost. Why should all homeowners pay for the board's mistakes? A woman named Susan, who'd been fighting her own violation about her mailbox design, stood next. "I've received 4 violation notices in the past 2 months for issues that never bothered anyone before. It feels like retaliation for questioning the board. How many other homeowners are being harassed?" Hands went up around the room. At least a dozen people. Tom, the board member who'd questioned the legal expenses before, spoke up. "Brenda, I think we need to discuss the board's direction. These legal costs are unsustainable and we're creating divisions in the community." Brenda's face was tight with anger. "This board has a responsibility to maintain standards. If homeowners don't like our enforcement, they can move elsewhere. Or we can recall the board," Richard said. The room went quiet. Brenda stared at him. "Excuse me." "The covenants allow for a recall election if 20% of homeowners petition for it. There are 240 homes in Pleasant Meadows. We need 48 signatures. I think we can get them." Murmurs of agreement rippled through the crowd. Brenda stood abruptly. "This meeting is adjourned." "You can't just adjourn because you don't like what's being said," Tom protested. "I just did." Brenda gathered her papers and walked out. The other board members sat in stunned silence. Over the next 2 weeks, Richard and I worked to gather signatures for a recall petition. We went door to door, explaining the situation and showing homeowners the financial records demonstrating the excessive legal fees. Many people had their own stories of harassment and petty violations. The petition signatures piled up quickly. We submitted the petition with 73 signatures, well over the required threshold. According to the covenants, a recall election had to be held within 60 days. That's when things got really interesting. A week after we submitted the recall petition, I received a letter from a new law firm, not Davidson and Associates. This firm, called Preston and Lee, informed me that they represented Brenda Morrison personally, and that I was being sued for defamation and harassment. The lawsuit claimed that I had made false statements about Brenda to other homeowners, damaged her reputation, and organized a campaign to remove her from the board based on lies. They were seeking $50,000 in damages. I called Jennifer immediately. She was skeptical when I explained the lawsuit. This is almost certainly a SLAPP suit, strategic lawsuit against public participation. It's designed to silence you through the burden of litigation. North Carolina has anti-SLAPP laws. We can get this dismissed and potentially recover legal fees again. So she's suing me to intimidate me into dropping the recall. That would be my assessment. Forward me the complaint and I'll file a motion to dismiss. I also shared the lawsuit with the other homeowners involved in the recall effort. Rather than intimidating them, it made them angrier. The petition signatures grew to over 100. Jennifer filed the motion to dismiss with a supporting brief that thoroughly dismantled Brenda's claims. Everything I'd said about the HOA's legal expenses was factually true and based on public records. Organizing a recall election was protected activity under both the covenants and North Carolina law. The lawsuit was clearly retaliatory. The hearing on the motion to dismiss was scheduled for 3 weeks later, which meant it would happen just before the recall election. In the meantime, strange things started happening again. My mail went missing for 3 days. I found a notice on my door from code enforcement about a supposed property violation, but when I called the city, they had no record of any complaint about my address. Someone spray-painted profanity on my mailbox. I installed security cameras. 2 nights later, the cameras caught Brenda's husband, Dennis Morrison, walking up my driveway at 2 in the morning and placing something in my yard. The next morning, I found a sign that said, "Warren Hutchins is a liar and a bully." I took the security footage to the police. The officer who reviewed it was the same one who'd taken my report about the attempted shed removal. His expression was grim. "This is harassment," he said. "Technically, it's also criminal mischief. Do you want to press charges?" "I want this documented," I said. "But I think pressing charges right now might escalate things further. Can we hold off unless it happens again?" "We can do that. I'll file the report and note that you have video evidence. If it continues, we'll have a pattern documented." I shared the video with Jennifer. "Save that," she said. "It might be useful." The motion to dismiss hearing was held on a Tuesday morning. Judge Connolly was not the judge for this case. Instead, we had Judge Raymond Porter, a younger judge who'd only been on the bench for a few years. Jennifer argued our motion efficiently, walking through each element of Brenda's complaint and explaining why it failed as a matter of law. I had stated facts, not falsehoods. I had exercised my right to participate in HOA governance. The lawsuit was retaliatory and designed to silence protected speech. Brenda's attorney, a woman named Rachel Preston from the new firm, argued that I had organized a malicious campaign against her client and made statements that damaged Brenda's reputation in the community. Judge Porter asked Preston a direct question. "Counselor, What statement did Mr. Hutchins make that was factually false? Preston hesitated. Your Honor, Mr. Hutchins told homeowners that the HOA had wasted money on legal fees. Had it? The legal fees were for legitimate enforcement. That's not what I asked. Did the HOA spend over $80,000 on legal fees in 3 years, as Mr. Hutchins stated? Yes, but the characterization as wasteful is defamatory. That's opinion, not a statement of fact. Opinion is protected speech. What else? Preston struggled through several more examples, but none of them were false statements of fact. They were all either accurate statements or protected opinions. Judge Porter issued his ruling from the bench. I'm granting the motion to dismiss with prejudice. Mr. Hutchins's conduct is clearly protected speech and protected activity under both the First Amendment and North Carolina's anti-SLAPP statute. Furthermore, this lawsuit appears to be retaliatory. I'm awarding Mr. Hutchins his legal fees and costs related to defending this action. Miss Preston, your client should be advised that continuing to harass Mr. Hutchins could result in further sanctions. Another victory, but I was getting tired of needing victories. I just wanted to live in my house without constant legal battles. The recall election was held 3 weeks later. It was conducted by mail ballot, with an independent third party counting the votes to ensure fairness. The results were overwhelming. Brenda Morrison and 2 other board members who'd supported her were recalled by votes of approximately 70% in favor of removal. A special election was held to fill the vacancies. Richard was elected president. Tom retained his position. 3 new members who'd promised to focus on actual community needs rather than petty enforcement joined the board. The first meeting of the new board was packed. Richard opened by acknowledging that the community had been divided and that the board's job was to heal those divisions and refocus on what mattered. We're going to conduct a full review of our legal expenses, Richard announced. We're also going to establish clear, written standards for violations so homeowners know exactly what's expected. No more arbitrary enforcement. The board voted to terminate the contract with Davidson and Associates and hire a new attorney who charged flat monthly fees for routine work, rather than billing by the hour for enforcement actions. They also voted to rescind the special assessment, instead using reserve funds to cover the legal expenses from the previous board's actions. I thought that would be the end of it. I was wrong. 2 months after the recall, I received a call from Jennifer. Warren, something interesting has come up. Remember how you thought there might be a conflict of interest with Brenda Morrison, the property management company her husband owns? Right. Well, I've been contacted by a reporter from the Raleigh News and Observer. They're investigating HOA corruption, and someone tipped them off about Pleasant Meadows. They've been digging into the finances and found something. What did they find? Davidson and Associates was overbilling the HOA significantly. They were charging for work that was never done and inflating hours on actual work. The reporter found similar patterns at 3 other HOAs where Brenda Morrison served on boards. She'd push for aggressive enforcement, rack up huge legal bills, create dissatisfaction with the management company, and then advocate to hire her husband's company. His company would then get a lucrative contract, and somehow the Morrisons would end up with substantial financial benefits. That's fraud, I said. Yes, it is. The reporter is writing a story and he wants to interview you, but more importantly, he's contacted the North Carolina Attorney General's office. They're opening an investigation. The story ran 2 weeks later on the front page of the News and Observer's local section. It detailed the scheme Brenda and Dennis Morrison had been running across multiple HOAs in the Raleigh area over the past 5 years. The legal fees at Pleasant Meadows were just one example. 3 other communities had similar patterns. The article interviewed me, Richard, and several other homeowners who'd been targeted with excessive violations. It also included a statement from Davidson and Associates claiming they'd been unaware of any overbilling and were conducting an internal investigation. The North Carolina Attorney General's office released a statement saying they were investigating potential fraud and corruption related to HOA governance in Wake County. Within a month, criminal charges were filed. Brenda Morrison was charged with fraud and embezzlement. Dennis Morrison was charged as a co-conspirator. Martin Davidson, the attorney, was charged with fraud and professional misconduct. The charges alleged that they had worked together to defraud multiple HOAs out of hundreds of thousands of dollars through overbilling schemes and kickbacks. The legal process took over a year, but eventually, all 3 defendants accepted plea deals. Brenda Morrison pleaded guilty to fraud and embezzlement and was sentenced to 18 months in prison followed by probation. Dennis Morrison received a similar sentence. Martin Davidson was disbarred, pleaded guilty to professional misconduct, and received probation along with orders to pay restitution. The various HOAs that had been defrauded, including Pleasant Meadows, received restitution payments, though they didn't cover all the money that had been stolen. Pleasant Meadows received about $40,000 back. Through all of this, my generator shed sat peacefully in my backyard, doing exactly what it was supposed to do. It provided power during outages, ran its weekly test cycle, and never bothered anyone. The new board never questioned it. Life in Pleasant Meadows gradually returned to normal. Richard proved to be an excellent HOA president, focused on maintaining property values through reasonable standards rather than petty tyranny. Violation notices became rare and were only issued for legitimate problems like truly overgrown yards or safety hazards. I attended board meetings occasionally, usually just to stay informed. The community felt different now. People were friendlier. Neighbors actually talked to each other instead of living in fear of violation notices. One Saturday afternoon, about 2 years after the whole ordeal began, I was in my backyard grilling when Richard stopped by. He'd brought a 6-pack of beer, and we sat on my deck overlooking the generator shed. "You know," Richard said, "if you hadn't stood your ground, we might all still be dealing with Brenda's nonsense. None of us would have organized. She'd still be running her scam." "I just wanted to keep my generator," I said. "Sometimes the small battles are worth fighting." "You proved that covenants mean what they say, not what a power-hungry board president wants them to mean. That matters." We sat quietly for a while, drinking beer and enjoying the pleasant afternoon. In the distance, I could hear kids playing in someone's yard and the sound of a lawnmower. "I've been thinking about running for the board when my term ends," Richard said. "Would you consider joining? We could use someone with your attention to detail." I considered it. A year ago, I would have said absolutely not. I'd spent enough time dealing with HOA politics. But the truth was, serving on the board was the best way to make sure the community stayed on the right track. "Maybe," I said. "Let me think about it." "Fair enough." Richard left about an hour later, and I went back to my grilling. The generator kicked on for its weekly test cycle, running smoothly for 5 minutes before shutting off automatically. Everything working exactly as designed. I thought about the journey from that first violation letter to where we stood now. I'd spent probably $15,000 on the shed and generator, another $8,000 on legal fees that I'd eventually recovered, and countless hours of stress and frustration. I'd been harassed, sued for defamation, and had become somewhat infamous in my neighborhood as the guy who took on the HOA. But I'd also helped expose a criminal scheme, improved my community, and established legal precedent that would protect other homeowners from similar abuse. The case had become somewhat known in property law circles in North Carolina. Jennifer told me she'd been contacted by other attorneys handling HOA disputes who wanted to cite our case. Most importantly, I'd proven a fundamental principle. Homeowners have rights, and HOAs can't simply make up rules that don't exist in the covenants. That principle mattered. It was the foundation of property rights and the rule of law in residential communities. The criminal prosecution of Brenda, Dennis, and Martin had sent a message to other HOAs as well. Several boards in the Raleigh area had conducted internal audits of their legal expenses and made changes to prevent similar abuse. The North Carolina legislature had even introduced a bill requiring greater transparency in HOA financial management, though it was still working its way through committees. I finished grilling and ate dinner on my deck, looking out at my yard. The shed looked good, professionally built and well maintained. It had become something of a symbol in the neighborhood. Several neighbors had since installed their own generator sheds, all following the same specifications I'd established. The new board had even created a simple one-page guideline for generator installations based on my design, ensuring consistency while respecting property rights. My phone rang. It was Jennifer. We'd stayed in touch even after the cases were resolved, and she occasionally sent me articles about HOA law developments. "Warren, I wanted to give you a heads up," she said. "There's a property law conference in Charlotte next month, and they've asked me to present on HOA overreach. I'm using your case as the primary example. I wanted to make sure you were okay with that." "Of course," I said. "If it helps other people, absolutely use it." "Thanks. I also wanted to tell you that I've been contacted by 3 other homeowners in North Carolina with similar situations. Sheds, solar panels, gardens, all code compliant but being targeted by overzealous HOAs. Your case gave them hope that they could fight back." "That's good to hear." "It is. You set an important precedent. Not just legally, but in showing that homeowners can stand up to board members who abuse their authority." After we hung up, I sat thinking about how strange life could be. I'd never intended to become an HOA crusader. I just wanted to install a generator so I could work during power outages. But circumstances had pushed me into a much larger battle, and I discovered that I had the stubbornness and resources to see it through. The sun was setting, casting long shadows across my yard. The generator shed stood solid and functional, a testament to proper planning and the rule of law. It had cost me far more than $15,000 in money, time, and stress, but it had been worth it. I thought about all the people who'd been involved in this journey. Jennifer, who'd fought expertly on my behalf, Richard and the other neighbors who'd stood up when it mattered. Tom, the board member who'd had the courage to question Brenda even before the recall. Judge Connolly, who'd cut through the legal nonsense and ruled based on what the covenants actually said. The reporter who'd investigated and exposed the broader corruption. And I thought about Brenda Morrison, sitting in prison for her fraud. Part of me felt a strange mixture of satisfaction and sadness about that. She'd brought it on herself through greed and abuse of power, but it was still a cautionary tale about how small authority can corrupt people who aren't prepared for it. The HOA president position had given her power over her neighbors, and she'd used it not to serve the community, but to enrich herself. She'd created conflict and division where none needed to exist, all in service of a scheme that was ultimately discovered and prosecuted. Now she'd lost everything: her reputation, her freedom, her standing in the community. It didn't have to be that way. The HOA could have been a force for good, maintaining property values and community standards through reasonable, transparent policies. Instead, it had become a weapon used against the very people it was supposed to serve. The new board under Richard's leadership was showing what an HOA could be when run properly. They focused on real issues like maintaining common areas, organizing neighborhood events, and addressing actual safety concerns. Violation notices were rare and justified. Homeowners felt like they were part of a community rather than subjects of a petty dictator. I finished my beer and went inside. I had work to do in the morning, a client presentation that required preparation. Thanks to my generator, I knew that even if the power went out, I'd be able to work without interruption. That peace of mind was what I'd been seeking all along. Later that night, as I was getting ready for bed, I checked my email and found a message from a homeowner in Wilmington, North Carolina. He'd read the News and Observer article and wanted advice about his own situation. His HOA was trying to force him to remove solar panels that were code compliant but supposedly violated aesthetic standards. I wrote him back with Jennifer's contact information and a brief summary of my own experience. I encouraged him to document everything, know his rights, and stand firm if he was in the right. As I hit send, I realized that this had become part of my identity now. I was the generator shed guy, the homeowner who'd taken on an abusive HOA and won. People would probably remember that about me for years. At first, that thought was uncomfortable, but I'd come to accept it. There were worse things to be known for than standing up for your rights and helping expose corruption. If my experience could help other homeowners avoid similar abuse or give them the courage to fight back, then everything I'd been through had purpose beyond just protecting my own property. I went to bed that night feeling content. My home was mine, governed by rules I'd agreed to when I bought it, but protected from arbitrary enforcement by the rule of law. My community was healing from the divisions that had been created, and the people who'd abused their power were facing consequences. The generator shed sat in my backyard, silent and ready, exactly where it belonged. It would be there for years to come, a reminder that sometimes the most important battles are the ones fought over principles rather than just property. The principle that homeowners have rights. The principle that HOAs must follow their own covenants. The principle that no one is above the law, no matter how much power their position gives them. That shed, which had seemed like such a simple project when I started, had ended up teaching me profound lessons about community, law, persistence, and the importance of standing up for what's right even when it would be easier to back down. I was glad I'd built it. I was glad I'd fought for it. And I was glad that the fight had led to positive changes that went far beyond my own backyard. As I drifted off to sleep, I could hear the faint hum of the neighborhood settling in for the night. Somewhere in the distance, someone's generator kicked on, probably on a test cycle just like mine. I smiled. The precedent was spreading. Homeowners were learning their rights, and HOAs across Raleigh were learning that they had to follow the rules they were supposed to enforce. It had been a long, difficult journey from that first violation letter to this moment of peace. But we'd made it through, and our community was stronger for it. That was worth every hour of stress, every dollar of legal fees, and every moment of doubt along the way. The generator shed remained, code compliant and unassailable, a monument to the power of doing things right and standing firm when challenged. And that was exactly how it should be.